The flame that Giuliani lit with those lies and passed to so many others to keep that flame blazing changed every aspect of our lives.
Money will never solve all of my problems. I can never move back into the house that I called home. I will always have to be careful about where I go and who I choose to share my name with. I miss my home, I miss my neighbors, and I miss my name.
So powerful. Joining me now, Barbara McQuade, MSNBC legal analyst, former U.S. attorney, law professor at the University of Michigan School of Law, and the co-host of the Hashtag Sisters in Law podcast. Barb, that's some really powerful messaging, right? Ruby Freeman saying she misses her name. I mean, frankly, you and I wouldn't even know about Ruby Freeman and Shaye Moss if it wasn't for Donald Trump, Rudy Giuliani, and others. Talk about what you think is the viability of an appeal by Rudy Giuliani for that verdict that came out yesterday.
That's a really interesting question, because one of the things that is a bit of an obstacle to an appeal is the idea that in Georgia, a person has to post what's known as an appeal bond. And the idea behind an appeal bond is an appeal could be filed for good faith reasons. It could also be filed simply to delay the payday. And so to avoid the latter, litigants are required to pay in advance an appeal bond, which is usually something more than the amount of the judgment, so that it's there in case there is a finality on the case. I don't know that Rudy Giuliani is going to get an appeal bond, so he may not be able to do it at all. I think one remedy he does have available is what's known as remittitor, which is file a motion with the trial court that handled this case to say that this amount is excessive. But even if there is some reduction in this amount, we're still talking about tens of millions of dollars here.
Yeah, and Barb, let's be clear. If he sought remittitor, this motion by him to actually reduce the amount of the jury verdict, Judge Beryl Howell, she's the one who actually entered the default judgment against him for his repeated violations of discovery. Last night, I had the chance to interview one of the lawyers for Ruby Freeman and Shaye Moss, and she made it clear it was years leading up to the fact that Giuliani didn't comply. So does that actually militate, towards him not being able to successfully getting a reduction in the verdict?
Yeah, that's a really interesting issue. You know, he has failed to disclose how much money he actually has. He claims to be broke. Now, maybe that's just a convenient story, or maybe it's the truth, but because he has concealed his finances, nobody knows about that. So, you know, there's a doctrine of unclean hands that says you can't get relief if you are not coming and being forthcoming with your own facts. So I think that could very well be a factor here. Unless he wants to share all of his finances, it seems unlikely that he's going to get that kind of reduction.
Barb, let's shift gears. Let's talk about Mark Meadows' 11th Circuit Court of Appeal hearing yesterday. You and I following it closely. Very quick, 30 minutes, 15 minutes to each side. We've heard some discussion already about the idea that Meadows' claim that everything he did when he was White House Chief of Staff is protected federal conduct, and that's the reason why he should get the benefit of removal to federal court. But I wanted to focus on another issue that came up yesterday, and that's this idea of statutory construction. So the removal statute says, and the one that he's traveling under is the idea that it doesn't include former federal officials, which is exactly what Mark Meadows is. It's a really technical thing, and yet it kind of seems like an off-ramp for these judges to be able to affirm what the trial court did, which was reject Meadows' ability to go to federal court.
Yes, well, that was the position of the Georgia prosecutors, and the chief judge, William Pryor, seemed to find value in this argument. He was quite aggressive in his questioning of the lawyers for Mark Meadows here about this idea, and said, look, in the statute, it talks about federal officers. It doesn't say anything about former federal officers. You know, if textualism means what conservatives say it means, then you can't make up words that are not in the statute. And so that's what this comes down to, that regardless of whether this was in the scope of his duties or not, the fact that he's no longer in office means that this statute does not apply to him whatsoever. But I think he loses on either grounds if the court makes that finding, or if instead it does take that broader finding about the inclusion of former. I just think it's very difficult for him to say that when he was setting up calls with Brad Raffensperger or trying to squeeze his way into the room where the audit was being done in Georgia, that was somehow within the scope of his official duties. Those are state responsibilities, not presidential responsibilities.